Committee are hereby advised of their duty under the State Government Ethics Act to avoid conflicts of interest and the appearance of conflict, and are instructed to refrain from participating in any matter coming before this committee with respect to which there is a conflict of interest or appearance of conflict. Any conflicts to be noted at this time? All right. We'll go ahead and move along. First matter is approval of the minutes of the Executive Committee's meeting on July 15th, 2021. And then the proposed minutes of the Council's meeting on July 16th, 2021. Those were in your materials. Do I have a motion as to those? Second? Second. Thank you. Any discussion, questions, comment? All in favor, say aye.
Aye.
All opposed? Motion passes. I'll ask Darren Jordan to give our financial report.
The third quarter financial statements, we just need to let you know, Barbara couldn't wait to get out of the presidency, so we moved up this meeting early, and so Jaya has not been able to get the financial statements prepared because bank statements haven't are just now coming in for September. So what we are asking, the Finance and Audit Committee is asking, is that you provide us the authority to review and approve those third quarter financial statements when they are prepared later this month. So that would be a motion coming out of the Finance and Audit Committee. It doesn't need to be seconded.
Any questions or comments? Okay. All in favor, say aye.
Aye.
Those opposed? Motion passes. Thank you.
The dues for 2022 are, the present dues are the statutory maximum of $300. We are expected to recommend with Finance and Audit Committee is recommending that those dues be set at $300 for 2022, and that would be our recommendation coming out of the Finance and Audit Committee.
So we have a motion from Finance and Audit Committee to set the dues at $300. No second is required. Any questions, comments? All in favor say aye.
Aye.
Those opposed? Motion passes.
As you guys know from the dinner last night, John Dorsey resigned as trustee for the State Bar's pension plan, and we considered the name and appointment of an individual. I don't have that name. Gray Hutchinson. And so the Finance and Audit Committee are recommending Gray Hutchinson to be appointed to that as trustee of the pension plan. And I think, do you want to say something to that at all? I mean, I think you...
Gray is a Raleigh lawyer. He's a benefits lawyer, long-standing. He recently retired from Wyrick Robbins here in Raleigh, but he very much has a desire to serve, and he is interested in serving this capacity. He was recommended to me by both the other trustees, Don Dorsey, the one who's retiring, and the one who's continuing on, who is a planning attorney here in Raleigh, and also the financial advisor. The company that does the financial advising to the trustees was familiar with Gray, and they highly endorsed his appointment.
And I think he's got the same heart of service that Mr. Dorsey had, so I think we need to seize upon that. So that would be the recommendation of the Finance and Audit Committee, that we appoint Gray Hutchinson.
Okay, this does not require a second. Any questions or comments? All in favor say aye.
Aye.
Those opposed? Okay, passes.
Do you want to speak to the purchase pension plan?
I can do that briefly. There was a whole addendum that we published with these. There was an addendum that we published, which was quite voluminous materials. Anybody who's familiar with pension plans knows that they're quite lengthy documents. We had to do what's called a Cycle 3 restatement as required by the IRS. As a part of doing that, we also restated our plan as a government plan, not an ERISA plan. We sought the opinion of an independent benefits lawyer that it was appropriate for the state bar to do that. It has some definite advantages of removing some of the strict requirements that ERISA has that can lead to potential liability. So it's a plan that works for us, does everything we need it to do, and reduces some of our potential liability. So we're doing that. And then as a part of that restatement, we did a couple of policy aspects. One is to state that any special compensation that's paid upon somebody's retirement is not considered when considering compensation for that year for making a contribution to the plan for that year. And we also changed back to the policy that we had before COVID of only allowing our participants in the plan to take out one loan per year. During COVID, we increased the number because we thought people might be having some financial issues, but we think as a matter of sort of prudent management that we should limit those numbers. So we're back to just allowing one loan a year.
So what we're doing is we're asking to restate the money purchase pension plan from what it presently is, a ERISA plan, to a government plan. So that comes as a recommendation from the finance and audit. I'm sorry.
Does anyone know enough about this to have a question or a comment? My understanding is that eliminating the term ERISA reduced it from 90 pages to around 50. All in favor say aye.
Aye.
Those opposed? Motion passes.
If you've done any personal injury, you know ERISA is a dirty word, so anytime we can get rid of that, it's a good thing. So also with the pension plan is a indemnification agreement, and we are recommending the adoption of a new resolution, or seeking a resolution to enter into a new indemnification agreement, getting rid of the references to ERISA and also indicating that this plan is going to be a government plan instead of ERISA. So that would, and also adding the trustee, the new trustee that we are appointing to that indemnification agreement. So that would be the recommendation to, one, add the new trustee to the indemnification agreement, and two, take away the language about ERISA and put in the government plan.
All right, you've heard Darren's motion. It does not require a second. Any questions or comments? All in favor say aye.
Aye.
Those opposed? Thank you.
The same thing with the client security fund applies to, or that we were talking about with third quarter financial statements, applies to setting the client security fund. We're waiting for some information and some final numbers before we set that from the client security board fund board. It typically is $25, but it has been as much as $50 in the past. We're asking, the Finance and Audit Committee is asking for permission and authority from this body and the council to be able to set that amount at the time we get the figures, which will probably be in conjunction with the financial statements that we receive later in this month. So that would be our request in our motion.
All right, any questions or comments? All in favor say aye.
Aye.
Those opposed? Motion passes. Our next item is to approve our meeting dates for 2022. So everybody get out your pen and pencil and write these down or enter them in. I will read to you the proposed dates. January 18th through 21st. April 19th through 22nd. July 19th through 22nd. That would be in Wilmington. And October 18th through 21st. Do I have a motion to approve these dates? Second? Are there any questions, comments? All right, all in favor indicate by saying aye.
Aye.
Those opposed, motion passes. Darren, will you please give us the report of the Appointments Committee?
Yes, ma'am. At the April quarterly meeting, we appointed Stephanie Davis to a 3-year term as vice chair on the Disciplinary Hearing Commission. We have since found that Ms. Davis is eligible to serve as a vice chair for 2 years instead of 3, and her term would be expiring June 30th of 2023. So we're asking this body to make an amendment to the earlier action to indicate that her term will expire June 30th of 2023 instead of June 30th of 2024. That would be our, that comes from the Appointments Committee. We would ask that that be passed.
It does not require a second. Is there any questions or comments? Okay, all in favor say aye.
Aye.
Those opposed, motion passes.
All right. The next matter is the Client Security Fund, our Board of Trustees. There is one appointment to this.
I have the names here. Let's see.
I got it right here. There's one appointment to be made. W. Irvin Fuller Jr. is not eligible for reappointment. The committee met this just an hour ago, and we are recommending the appointment of Jim Dorsett, who I think is former State Bar President, to that position in place of Mr. Fuller. That would be our recommendation. You want me to go ahead and do the others also?
I think that's fine.
All right. Also, with Mr. Fuller not being eligible for reappointment, the current vice chair is L. Thomas Lunsford II, who we all know. And there is a recommendation from Mr. Fuller, who's leaving the board, that Mr. Lunsford be appointed chair and that Amy Richardson be appointed vice chair. It is common, well, I think it's required that the lawyer on that board who has the most years of service on that board be appointed as chair, and Mr. Lunsford has that. So we would ask, and the vice chair is the second longest. So Mr. Lunsford and Ms. Richardson meet those qualifications. So Mr. Dorsett to replace Mr. Fuller, Mr. Lunsford to be the chair, and Ms. Richardson to be the vice chair. That's our motion.
Any questions or comments? All in favor say aye. Aye. Those opposed? Okay, motion passes.
The Board of Continuing Legal Education is our next board that we need to consider. There are 3 appointments. Adrian Blocker and Leanne Kane are eligible for reappointment. It's a recommendation of the Appointments Advisory Committee that Adrian Blocker and Leanne Kane be reappointed to the Board of Continuing Legal Education. You want to go ahead and take that? Do the other one?
Go ahead.
Okay. We also have George Jenkins, Jr., who is not eligible for reappointment to that body. The recommendation of the Appointments Advisory Committee is Dayton Cole from up in Boone be appointed to replace Mr. Jenkins. That would be our motion.
So we have a motion for appointment to the CLE Board for reappointment for Adrian Blocker, Leanne Kane, and the appointment of Dayton Cole. Any questions or comments? All in favor say aye.
Aye.
Those opposed? Thank you. Motion passes.
Mr. Jenkins is the current chair. Judge Beth Keever is the vice chair. Because Mr. Jenkins is going off that board, we have to replace both the chair and the vice chair. It's a recommendation of the board, pursuant to a recommendation that we received from the Continuing Legal Education Board, that Judge Beth Keever be appointed chair and Adrian Blocker be appointed vice chair.
Any questions or comments? All in favor say aye. Aye. Those opposed? Thank you. Motion-
Board of Paralegal Certification, there are 3 appointments. Matt Smith, who I guess is going to want to recuse himself of this vote.
So noted.
and Benita Angel Gwen Powell are eligible for reappointment. We are recommending that Matt Smith and Ms. Powell, Gwen Powell, be reappointed to those positions. There is also an appointment with Patty Clapper is not eligible for reappointment. She is the paralegal on that board. We've taken consideration of recommendations from the Board of Paralegal Certification and would recommend that S.M. Canodal Hodges be appointed. I think she's a paralegal in Charlotte, I think somebody said. That would be our recommendation with regards to the Board of Paralegal Certification for those positions.
Do you want to go ahead and deal with the chair and
I
vice
will.
chair?
The chair is currently Warren Hodges. The vice chair is Brian Scott, and we are recommending that those two individuals be reappointed for those positions as chair and vice chair of that board.
Thank you. Any questions or comments on that motion? All in favor, say aye. Aye. Those opposed? None. Thank you.
And the simplest one we had today was the Board of Law Examiners. There are 3 appointments to be made. Ron Baker, Calvin Murphy, Ron Gibson, all former presidents of the state bar, are all eligible for reappointment. And it's our recommendation that we reappoint those 3 individuals.
Any questions or comments? All in favor, say aye.
Aye.
Those opposed?
Our report.
Thank you. Right. Our next item is a proposed rule amendment for publication. And David Allen, would you like to make a motion that we add a new comment? We publish this proposed new comment to Rule 1.01 competence, which states that awareness of implicit bias and cultural differences enhances a lawyer's competency.
That is committee and studying this, something to follow that recommendation to come to the capacity of this committee.
So we have the motion for publication. Any questions or comments? Okay, this would be going to the full council to approve publication. All in favor, say aye. Aye. Those opposed? Okay, thank you. And we have amendments to the standards for the certification in criminal law. Those were published for comment and no negative comments were received. Those were printed in your materials. Do I have a motion to transmit those to the council for adoption? Second?
Second.
Okay. Any discussion? All in favor, say aye. Aye. Those opposed? Motion passes. Thank you. All right. All right, I'd like to ask Ms. Jean if she will give us her litigation report.
Yes, we have 2 matters pending that this body authorized the Authorized Practice Committee to file. One is against a Brett Fox. He was served. He has failed to file an answer. We'll be moving for default judgment shortly. The second one is Valerie Arroyo. She has filed a counterclaim. We have moved to dismiss, and that motion will be heard on October 25.
Any questions for David Johnson? Thank you.
Thank you, David. The rest of the litigation is litigation that was initiated by the state bar in various fora across the state. None of them is of any particular moment, and I'd be happy to answer any questions, but they're described in the litigation report. Anyone have any questions? Thank you, Madam President.
Thank you. And I'll just ask you to hold on to that. Our next item is a little bit unusual in that The State Bar's IOLTA program has been asked to join in an amicus brief, and I will ask Catherine if she wants to kind of give us the overview of that request.
Yes, ma'am. May I take this off?
Please do.
Can't think very well with that on. Oh, the case is called Krakauer versus Dish Network. It's a Fourth Circuit case. The basic case is about, it's a class action involving robocalls by Dish Network, annoying robocalls, and so there's a large class of claimants, potential claimants. They're, after distributing the money that was, where they could identify the correct claimants and their addresses and the checks were cashed and everything, there's about $10 million left over. Often in these class action cases, if there's money left over that they can't reasonably distribute to the rightful claimants, they will ask the court to enter a cypre award so that legal aid societies and other public interest organizations will receive the benefit of that money. Sometimes it's for general purposes, sometimes it's for very designated purposes. You may remember that the State Bar, the IOLTA program, was a beneficiary of a specific, very targeted cypre award that had to do with mortgage foreclosure avoidance. Is that right, Mary? Some years ago, had to do with that particular subject matter? It was, okay, okay. Well, I apologize for that. Sometimes they are very targeted and sometimes they are more general. There have been challenges in other jurisdictions to the validity of cypre awards, and the courts have consistently concluded that cypre awards are appropriate, that they are not unconstitutional and do not violate federal law. Notwithstanding that, this is the first time that the issue has been addressed in the Fourth Circuit. And those are the arguments that are being made, that a cypre award is unconstitutional, violates various federal statutes and rules, and that the court should not be taking residual money that's left over from a class action and giving it to anyone other than the defendant who paid the money in the first place. So they're basically saying residuals should revert to the defendant. So this issue has not been successful in other jurisdictions, but it is the first time it's going to be addressed in the Fourth Circuit. The State Bar is being asked to, the IOLTA board of the State Bar is being asked to sign on to the amicus brief. If it does so, its name will appear on the amicus brief. There's no cost associated with this. This work is being done pro bono by the law firm of McDermott, Will, and Emery, which is a large law firm. They do very quality work. We don't have the brief here right now to look at, but we do have an example of a brief that that firm has filed as an amicus brief in a similar type case. And I will tell you that the quality of their work is very good. So would you like for me to provide a legal opinion about whether this is a good thing to do?
I think that would be very helpful, but if you don't mind, maybe we can just wait until the end of the meeting when we're probably going into closed session anyway.
Yes, ma'am. Okay, thank you.
Mary, did you have anything you wanted to add or say? A significant issue. Thank you. All right. So at this point, if it's all right with the committee, I'm just going to move along, and then again, I anticipate we'll go into closed session at the end, and we can see counsel. So I understand there is no report today from the legislative committee. Is that correct, Jay?
That's correct.
All right, then, Eben, I'll ask you for the report of the PMBR/Cybersecurity Committee. You Your main job was to change the name of that, and that hasn't happened yet.
We have now handed off the work product of 4 separate work groups to Catherine Fry, Warren Savage, and Patty Head, who we call our lipstick and makeup work group. And they have a draft of a very productive meeting that we had a couple of weeks ago with our subject matter experts. And we have distilled the work products of these 4 different work groups into one document that we're having trouble naming it. We've called it a self-assessment tool, but we're concerned about how the optics are going to look when lawyers actually get involved in it, and whether lawyers are going to be afraid it's going to affect liabilities if they take it and they're deficient in their self-assessment. So various names have been thrown out there, calling it a checklist and some other stuff, but it's going to be Catherine and Warren and Patty who I think are going to come up with a suitable name. We have some resource clicks in the document where we can just click on resources and go directly to those websites. And it's basic. It is designed primarily for sole practitioners, small law firms, not for the large firms that have IT specialists involved on staff. So it's a basic document that is a portal and also an educational tool. We're hoping perhaps in January we might have a finished product that we can look at. But I'm pleased that we've managed to herd this many cats, herd this many work groups, distill this down into a single document with resources and rules that are identified in the document. So I'll report back in January unless somebody else takes over this committee like Walter coming in the next session.
Any questions for Eben? Thank you for all your hard work. I mean, any of you that have reviewed the grievance agenda know that I don't believe there's been a quarter that has passed in the last 3 years or so where we've not seen that lawyers have been the victim of cyber fraud. So it's a much-needed resource. Thank you. Okay, Andrea, would you present the report of the Authorized Practice Committee? Wait just one second.
I can do it with that, that's fine. So, okay. 11 complaints, 6 of those were letters of caution, 4 dismissed. 1 was, no action was taken. 2 prepaid plans were registered, done.
Wow.
You are an efficient machine. Okay. Any questions for Andrea? Thank you. All right, Marcy, you present the report of the Issues Committee.
I don't think I can beat Andrea. No. So the Issues Committee currently have, until today, we had four different subcommittees looking at 4 very important issues. 2 of our subcommittees are still working, and we do not really have a report today on those committees, and those are the Subcommittee to Study Regulatory Change, and I believe Mark will come back to us in January on that subcommittee, and the Subcommittee on Diversity and Inclusion. I believe Todd will come back to us in January with the report from that subcommittee. But I am very proud and very happy to talk with you today about the results of 2 other subcommittees from Issues. One is the Subcommittee on Compensation of Court-Appointed Defense Counsel, and that was led by Alan Cobb. Is he here? I'm not sure he's here. And before I even talk any more about that, I want to recognize the staff that worked so hard to support this subcommittee. These staff members are actually from the Office of Counsel, so they sort of had to step out of their comfort zone a little bit and come into another situation, and they have been, it could not have happened without them. If Alex Nicely and Jennifer Slattery will stand up and let us recognize you, and thank you. So you have this really, it's amazing report, frankly. It's in your materials, but I feel like it's summed up by the very last paragraph of that report, and hopefully you've had a chance to look through it. They did an amazing survey. It was just so well done, well thought out, and it's extremely helpful tool. But the closing remarks, and I think it's worth us reading that, and I would like to do that if you don't mind. It says, an alarming number of attorney respondents reported that due to the size of their caseloads, they were unable to perform critical tasks with reasonable effectiveness. Moreover, attorney responses indicated that experienced attorneys are choosing to remove themselves from local court-appointed lists, contributing to the workloads of those attorneys remaining on the list and leaving a less experienced pool of attorneys to handle complex cases. When asked to explain their decision to remove themselves from the court-appointed list, a significant percentage of attorneys cited low compensation as a contributing factor. And based on the results of the survey, the subcommittee is concerned that excessive caseloads may be hindering the ability of court-appointed counsel to effectively represent their indigent clients. And of course, those of you that practice in the criminal law area know what I'm talking about, and then those of us that do child support, talk about contempt in child support cases where there's a need for a court-appointed counsel. So a very important and timely issue. So the motion before you today is that this report be distributed to the following: to the Chief Justice, the Chief Justice's Commission on Professionalism, the North Carolina General Assembly, IDS, North Carolina Bar Association, North Carolina Advocates for Justice, North Carolina Association of Women Attorneys, all the Black Attorneys Associations, North Carolina Conference of Superior Court Judges, North Carolina District Court Judges Conference, the North Carolina District Attorneys Association, Administrative Office of the Court's Director, Attorney General Josh Stein, and Governor Cooper. There may be others, that if any of you can think of any others that groups or organizations that you think would benefit and could actually help to try to continue the work to alleviate the concerns of this report. The subcommittee also, and the Issues Committee, would encourage attorneys to write articles in different media outlets to bring forth this concern and the problems that the subcommittee points out. So that is the motion before the Ethics Committee.
So we have a motion from the Issues Committee. Doesn't require a second. Are there any questions or comments? Discussion? All in favor, say aye. Aye. Those opposed? Okay, thank you.
The other subcommittee on the to study the secure leave subcommittee. I also, at this time, I don't mean to embarrass anybody, but that subcommittee, of course, at the helm was Gordon Brown, who did a fabulous job with his committee members, and they're listed in the materials. But again, we all know without very strong support staff, it wouldn't happen. None of this would happen. So I would like for Savannah Perry and Cameron Lee, if you are here, would you stand up and let us recognize you? Thank you. I believe both Cameron and Savannah are also from the Office of Counsel, so they kind of stepped out of their comfort zone and helped out with this very important issue. So again, these materials are in your, well, on the file. You can go through and read those. But basically, some of the changes that the subcommittee are recommending is that within a calendar year, an attorney may enjoy 20 days of secure leave for any purpose. That the secure leave may be taken in minimum blocks of 2 consecutive days, provided the total designated and taken time does not exceed 20 days in a single calendar year. That Saturdays, Sundays, and holidays observed by the courts of North Carolina are disregarded for counting purposes. A secure leave period that crosses from one calendar year to another will be counted only against the calendar year in which the day actually occurs. That when secure leave is for birth or adoption is specifically in addition to the secure leave allowances for any purpose. The designation submission period is reduced from 90 to 45 days before the secure period begins and before a proceeding in any of the attorney's cases is scheduled. that otherwise conflicts. In an event an attorney's plans for secured leave change in whole or in part, the attorney may move the secured leave to a different period by serving written notice of a modified secured leave period at least 45 days before the modified secured leave period begins. Those are the recommendations. And then the other issue that the subcommittee, and there may be some other recommendations, but those are the highlights of that. I think there were some grammatical changes that were made to the Rule 26 and the appellate as well. And then the other issue that the subcommittee studied was whether or not we could have a portal where all secured leave could just be put into a system and there'd be one place, because all the different districts have their own rules and forms as it relates to secured leave, and a lot of attorneys practice in a lot of different areas. So before you today is a motion from the Issues Committee to send these recommendations to the Supreme Court and to the Office of Administrative Hearings. That's the motion.
Does not require a second. Any questions or comments? Discussion? All in favor say aye.
Aye.
Those opposed? Thank you.
And that is the report of the Issues Committee.
This is important work, and the committees have done a great job, and each and every one of you that have served on it should really be proud. I'll echo the thanks to the staff. We also had staff from the Office of Counsel chair some of our other subcommittees, and they've done this in addition to the difficulties of working during a pandemic and also while being somewhat short-staffed themselves. So thank you again. Is Dorothy here to give the report of the Communications Committee? Peter, would?
I think Dorothy will give her, she's going to give her report tomorrow.
No action items for us?
Yeah.
Okay. Thank you for communicating that. I will call on David for the report of the Ethics Committee.
Very lively, a very helpful and lively meeting today. The Ethics Committee, there are no action items to come before council for tomorrow. We do have a number of matters that we'll discuss with council David and that, but no action items.
All right, thank you. All right, then, Warren, do you have the report of the Distinguished Service Awards Committee?
Yes, before I move into closed session, I'd like to bring something up that we discussed at our committee meeting that we're going to be looking at before January's meeting. There was an expression of a lot of frustration at the committee meeting about the untimely death of folks that we care much about and think should have been available to be nominated for Distinguished Service Awards. So we've asked Suzanne to sort of pull out the present criteria, maybe work with Alice and Peter to look back at the legislative history of that criteria, and hopefully come to the council in January with maybe some tweaks to that. If we decide to do it, we don't know, but it's just something we're considering. If you have any opinions about that, I'm not sure that the original reasons for that, no posthumous awards, when we first did it, does that same reasoning still apply 10, 12 years later, so after we've been doing it? So I don't know. So we're going to look at that along with some other stuff with that criteria. With that said, so think about it, and if you have any opinions, address to Walter or me, other Catherine, other folks that are on our committee. And at this time, I'd like to move to go into closed session pursuant to two provisions, GS 143-318.11A2, to prevent the premature disclosure of an honorary degree, scholarship, or similar award, and also under subsection 3, to consult with our attorney, Catherine Jean, in order to preserve the attorney-client privilege on another matter that we previously discussed.
Do I have a second? Any questions or comments? All in favor, say aye.
Aye.
Those opposed? Okay, and then we will return to this special matter where, again, we have been asked to join in an amicus brief in the case of Krakauer versus Dish Network. It's class action. And do I have a motion as to what we should do to that, Mark?
I would move that we authorize Catherine Jean to sign that brief on behalf of the State Bar's IOLTA program, provided she reviews it and determines that it's appropriate within our scope and with the approval of the office, so that we give authority to sign subject to those conditions. Second.
Okay, we have a motion and a second. Any questions, comments, or discussion? All in favor, say aye.
Aye.
Those opposed? Warren, as you were giving your report, and I'm sorry I missed the meeting of the Distinguished Service Award Committee, but I do understand that there was discussion about those we've lost, and I thought perhaps in closing that we might just take a moment and just lift up the names of anybody, whether it's someone you know individually or we know as a body, and perhaps I love the way that my Quaker friends refer to it as, let's just hold them in the light and remember them and their families. So if we'll just take a moment of quiet and just call out a name as it comes to you.
David Friedman.
Barry Collins.
We will just ask for peace and comfort for their families and those that love them. Any other business?